and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting has stepped into the room, well, some room somewhere, and we've beamed him in, Scotty, so he can actually answer your questions and offer some legal advice. 1300 222 774. I've got some free lines. I've got 1, 2, 3. I've got 4 free lines. Are you kidding me? It's usually, well, more scarce than hen's teeth getting a line to talk to David Whiting. So quick, don't walk to the phone, run and call 1300 222 774 and David can help you out. Good morning, David.
Good morning, Virginia.
Question without notice. What's your understanding of how stringent the regulatory regime, at least it's constituted so far, is for any operator or any holder of the Victorian casino licence? Therefore, how hard would it be for any government to try and get somebody else, some other mob, to run the casino?
I only looked very, very briefly at it. I wonder what power you're going to put to a supervisor. But I suppose it's such a unique product. Let's assume they were told to divest themselves of the licence. By the time you were verifying the identity of a new entrant, it's a 2 or 3 year process.
Exactly.
So that's the problem. It's too much of the state budget for us to say they should lose their licence, go away. And it's also the largest single-site employer in Victoria, which is also a factor.
Yeah, well, so does that mean then, in effect, that Crown Casino or Crown Resorts can get away with anything because they're always going to be assured of holding that licence?
Well, someone's got to make the hard decision. And to me, the hard decision would be you have a licence for this period of time. In the interim, we're putting in these people to supervise each and every one of your activities and you're paying for them. And if you haven't found a buyer by this date, well, goodbye. And that's a really hard call when you look at the amount of money the state government uses from the casino to pay for other things.
Yeah, look, it's a stalemate. We're stuck with them and they're stuck with us.
Yes.
Oh, it's quite incredible, really. Do you think, just reflecting on what a Royal Commissioner is beholden to in making their assessments and their judgments and writing their recommendations, that Commissioner Ray Finkelstein would have actually had that in mind, that he would have felt that he had to be mindful of the fact that the Crown Resorts was such a key employer, that it funneled so much crucial money to the state government, and therefore his recommendations had to be mindful of that?
Well, I've not looked at his terms of reference, and you often find that the terms of reference is, in a sense, turns the mind of the Royal Commissioner to a solution that might work. But if I was the Royal Commissioner, and that's never going to happen, but if I was the Royal Commission, the answer would be I would need to think of the consequences of the decision that I made. And that would be one of them. Well, what happens if we close it down?
You might get asked to be a Royal Commissioner one day.
Yeah, right, okay.
What would your special subject be, David?
Oh, the essence of a good Royal Commissioner is the subjects are at large, you know.
Yeah, well, that's true.
Fences, I think. Fences or trees is probably where it would end up.
I love it. A Royal Commission into fencing disputes. I'd attend.
Well,
I'd attend every day.
And can I say that there were some proposed amendments from the Victorian Law Reform Commission that the government is still considering and has been for a couple of years. So who knows?
It may result in that. 1300 222 774. Let's get to some legal advice. That's what you're here for. Let's start with something a little ephemeral, I guess, and philosophical, but I do like this. Rosemary in Reservoir, what's your question? Good morning.
Oh, hello. How are you today?
Well, thank you. Go ahead.
Good, and thank you for letting me on. I live in a park for a residential park where I own the dwelling and rent site, and I'm trying to get definition of the boundaries of the site so that in order that I know where my responsibilities start and end with regard to the various rules of the park.
Well, Rosemary, I want you to think of the boundary as being an infinitesimally thin line between what's yours and what's theirs. Has the plan? Does the park have a survey? Have they pegged out the bits that you occupy or not?
No. I have requested a site plan with dimensions about 3 or 4 times and no response.
Then I would be asking the manager to indicate the lines of your site. That is the points that define it.
Yeah, I have requested in writing. I only ever do request anything in writing from these people because they do change their minds on a regular basis.
Then when they tell you, Rosemary, send them an email confirming what they've told you as the starting point, so that you've then got a written acknowledgement of what they have told you.
Oh, absolutely. So how do I force the issue and get them to actually provide me with a plan?
What I would like to do, I try and avoid homework wherever possible. Rosemary will understand.
I know.
But what I will do is I'll look at the Residential Tenancies Act insofar as they relate to that kind of occupancy and see whether there's a process there for defining the leased area.
Okay.
Well, so you have to listen next week.
Well, David will take that then on advisement and have a listen next week, and hopefully we can get you a solution. Thank you. Christine in Box Hill, what's going on? How can we help?
Hi, hello, Virginia. Like your show. And hello, David. I have a question. I rented a property. At the end of the renting, the agent said I should be responsible for the mold in the bathroom. And because I didn't clean the exhaust fan in the bathroom, the fan is very high up. I can't reach the fan. And I don't think the mold is caused by the exhaust fan because it's still working. The switch is for the light and the exhaust fan at the same time.
Mm-hmm.
Yes, so the fan is on when the light is on.
Yeah, that's so correct.
My view, Christine, is that you would be responsible to clean the bathroom at the end of the tenancy, including dealing with the mould. Yep.
Oh, is it? Yeah, but the agent organized the mold treatment before we move out. So I thought, they organized it, so I shouldn't be responsible for it.
I would like a look at your residential tenancy agreement, but my view would be that if there was no mould when you moved in, you would be responsible for cleaning the mould that arose in the premises during the time you were there, unless you wanted to argue that there was a structural or a defect in the premises that caused the mould, which is, Christine, I recently acted on the sale of a property in Kew where there was mould in several of the units in the development, and it appeared to be a construction issue. So there may be a ventilation issue for more than the bathroom. So why would you not, if it's an owners corporation, you might see if there's an issue there. But my general view would be if there was no mould when you moved in, you would be responsible for removing the mould when you moved out.
Yeah, but why the agent organized the mold treatment before we move out? So I didn't clean the mold when I moved out.
So there was no mould to clean when you moved out?
No, there was. They organized it before I moved out, but the treatment was done after I moved out. So they asked us to use our bond to pay for the mold treatment, but they didn't say that before we move out. Before the vacant
which I
date.
think is unreasonable, and so you could take the matter to the VCAT for the particular circumstances that you're in. But in talking about VCAT, I got an email this morning from someone who said that they lodged an application at VCAT and the hearing will be 2 years after the application was lodged.
Yeah, I was going to ask you, David, whether it's even worth the time or the effort or the money. Do you think it is?
For the cost of the mould removal, no.
No.
Christine, I feel really sorry that you're going to put more time and effort into this than the amount that they've deducted from the bond.
Yeah, maybe just let it go. Sorry, Christine. Christine in Ferntree Gully, another Christine. Good morning. Go ahead.
Good morning, Virginia. Good morning, David. Thanks for taking my call.
Go ahead.
I'm here on behalf of a friend who is trying to gain access to the will for her mother who died recently. It's a bit of a messy story. The will has
Christine,
been...
does she know where the will is?
She knows where the will is. She contacted that legal office, but they said they were unable to act on behalf of the will, and they had referred the executor to go somewhere else because of a legal conflict of interest in that office.
Okay. Christine, there is a provision in the Wills Act that says if a person dies, so your friend's mother has died, and you have custody of the will, then there are a whole group of people you need to provide a copy of the will to if they ask for it.
Yeah.
So if they still hold the will, then the issue is, then they have, if it's a law firm and they have the will and they're satisfied that the lady has died and your client, your friend is entitled to the will and will be as a child, then they have no basis for refusing to provide a copy. None at all.
So does she need...
You would then go in the event that that was the approach being taken by the law firm, is you would go to the regulator, you'd go to the Legal Services Commissioner and say, they have an obligation under this Act to provide me with a copy of the will, and they won't.
Yeah.
Now, the Act does say that you have to pay for the copy, but that's for the cost of producing the copy, not the advice that went with it. So, and, if it's if it's going to be $5 worth of photocopying, it's not worth processing the bill.
Yeah. So she can just go to the firm and say, can I please have a copy of the new will that my mother issued?
She can go to the firm and say, if you have the will, I want a copy. If you don't, who did you give it to? Because I'm going to ask the question of them.
Okay, we'll leave that there. But Christine, I hope that helps. Thanks so much. Chris in Eildon, what's happening?
Oh, good morning, Virginia and David. I bought a new ride-on mower 11 months ago, and a couple of weeks ago, while mowing, it caught fire and it was destroyed. So I've been to the people who I bought it off. It's a well-known manufacturer, and they've put me onto the manufacturer in Queensland, and I've sent photographs, and I've been in touch with a person. But they're saying that the warranty, which it's still under warranty, doesn't cover fire, and that I'll need to go through my insurance. So I'm just...
Chris, you need to have a look at the warranty and see what the warranty covers.
Okay, I haven't had a detailed look at that, David, no.
No, because it's for example, when you take a car in, there might be a deal that servicing for the first year is covered by your contract, but it doesn't pay for the replacement oil if it's needed. So look very carefully and see what the warranty is. If it is something that went wrong with the vehicle that caused the fire, then you have a claim against the manufacturer.
Well, that's what I'm thinking, because I don't know how the fire started, but it wasn't built up of grass or anything. It was actually in the engine, and I was able to hop off, and then it just engulfed the mower. So okay, so I'll have a detailed look at the warranty, and if it doesn't mention it doesn't cover fire, how do I go about a claim?
It will be covered by the warranty, but at that stage, you still have your Australian consumer law rights.
I see.
I take it this is for your house property?
Yes.
It's not a commercial operation?
No.
Then you've still got your Australian consumer law rights. And there would be an argument, to my way of thinking, that if it caught fire, it might not be fit for purpose.
Well, that's right.
Have a look at the warranty and have a look at the Australian consumer law.
Okay, good luck, and I hope that's really helpful. Natalie, along the Surf Coast, what a nice place to be. What's happening, Natalie?
Hi, Virginia. It's a lovely place to be when you've got a stable home to live in.
However.
So, my question, David, is about rental increases. So we've had a lease in a property and we were looking for a new lease, and they offered us a new one. We're now on month to month. They offered us an increase of $20 a week, which we accepted. And the agent said, we're just preparing the lease. And I confirmed it in writing to him. And then fast forward 2 months, he called us on Friday and said, in fact, they want to increase the rent by $110 a week. And so I know there's no limit on how much they can increase it by. And I know Consumer Affairs can review the rent. But what I want to know is, did we already have a contract? And even though there wasn't a lease signed, did we already agree to a contract with terms and an amount that I can insist on?
And Natalie, this is a kind of question that arises all the time. Do we have an agreement that comes into effect now, or do we have an agreement that comes into effect only when the formal document is signed?
Mm.
And I can't tell based on what you've told me but particularly because there have been a significant number of changes to leasing laws in the last 12 months. So, but Natalie, I would be... sorry, what do you think the market rent is? Your figure or their figure?
Somewhere in between. I mean, there's such a massive rental shortage that if we lose this lease, we can't live here anymore. So I suspect if they re-let it at the price they want, they would get tenants. But it's bordering on unreasonable. So it depends who
Natalie, that's your question. The question is there enough specificity in the documents that you've got to say that you have a concluded agreement for the lease? And at this stage, Natalie, you could then play a game with the agent because they're going to find it. They're going to have to give you notice to leave, and during that period, you'll be paying rent at the lower figure, not the higher figure. And they could give you a notice, and to which your answer would be, I have a new fixed-term tenancy. Here is the evidence in the exchange of emails.
Yeah.
Right, so,
okay.
But I would be more comfortable if somebody had a look at the document and say, does Natalie have a concluded lease agreement, or does Natalie have an agreement that's conditional upon the signing of a document? On one way you win, on the other way there is no current arrangement.
So I should get legal advice, essentially.
You should. I would be talking probably to a community legal service, because otherwise you're just going to be spending. It's going to be. What you'll do is you'll end up cheaper. It'd be cheaper to have the certainty of the new rent. So see if you can get half an hour with somebody and see if you can work it out.
Okay, I hope you can. Good luck.
Thanks.
Thanks for calling in, Natalie. Hope that's at least a push in the right direction. Marie in Glen Waverley has a question that I think is probably asked by many people. Hi, Marie, go ahead.
Oh, good morning, Virginia, David. I just want to know, how do you go about nominating a person for being a power of attorney?
You do it in a written document in a particular form, Marie.
It's a form, right?
You can get the document. You could buy a form at the newsagent.
Okay, cool.
Lawyers will fill it out for you. You
can lawyer.
Also get, let's assume you could start with the Office of the Public Advocate, so opa.vic.gov.au. They have a guide. They have a guide to powers of attorney. What you need, the things that you need to think about, what the form looks like. There is a template that you can download from the website for nothing.
Mm-hmm.
It's a great form. It's very clear. The guide is excellent. So have a read and probably use that for the form. And if you've got any other questions, then go off and get some other advice. There's also advice on powers of attorney at the Law Handbook, which is the lawhandbook.net.au.
Yeah, cool.
Thank you.
Good luck, and hopefully that's very helpful for you. Michael in Hawthorn, you're owed some money, are you?
Occasionally. Good morning to you both. I do part-time handyman work, and they're often just small jobs, $100, $200 or something. And most of my customers are extremely happy and pay straight away. But occasionally you'll get one that says that just decides they don't want to pay, even though they're not saying they're unhappy with the work or anything.
Yeah.
To go to a lawyer and get a letter to collect that is probably going to be minimum of $200 or $300 more than the bill. Are there any other avenues or sort of official type warning letters, or I just don't know if there's any other choice besides just writing it off?
You could write your own letter of demand, Michael.
I have done that just in emails and stuff, and said, look, and followed up a couple of times.
Now, if you If you were to issue a claim in a magistrate's court, then you would need, by law, to write a letter of demand first, because the Civil Procedure Act applies and it essentially says you've got to try and resolve it first. If you decided to issue a claim in VCAT, then, and we have talked earlier today about delays at VCAT, but if you issued a claim at VCAT, then you would be successful or likely be successful to the amount of your claim and the fee that you pay VCAT for the issue. And you would still be significantly cheaper than paying someone to collect it for you.
Okay. And there's not lawyers who just do this as a routine thing like conveyancing that will issue a letter very cheaply and with the authority of a law firm behind it?
Well, you might find that there will someone, but my problem with those, Michael, because I get asked to write them from time to time, and you say, sure, give me the invoice and I'll write you the letter and it'll cost you this amount of money, but what do I do if they ring me up?
Mm-hmm.
I'm now making an investment in your matter that's different to the one we agreed to. So that's the problem. In fact, the issue fee at VCAT would be cheaper than the amount of money you'd need to pay a lawyer.
All right, thank you.
Okay.
So it's a civil claim at VCAT. The form's online, you pay online, it's all online.
Must be really hard having to just nag and have people you've, done work for in good faith, David, and then you've got to run around and spend that money just to get the money you're properly owed back. Enormously frustrating.
Yes, but it's also the time. I mean, magistrates' court every court is now, and VCAT is just now blown out with time constraints.
Yeah, well, I mean...
The answer might be a whole series of temporary magistrates and VCAT members for a period of a year and see whether we can't get the backlog down.
Yeah, is that being considered? Are there some moves afoot to try and speed through some of the backlog?
It's easier at VCAT because you can appoint people on a sessional basis.
Right.
But if you're appointing magistrates or judges, they all... while there is provision in the legislation for fixed-term appointments, the usual practice is that it's a job for life, and they need a whole series of more things.
Yep.
So I would have said, yes, it could be done at VCAT. It would be significantly harder to do in a court system.
Just before we quickly try and fit in one more call, I've got lots of texts coming in following Natalie from the Surf Coast and her particular issue, suggesting she contact the Tenants Union. Is there a great deal of value in that for her?
Yes, there is.
Okay, all right. Well, Natalie, if you are still listening, that might be a useful first phone call to make as well. Sarah in Keilor Park, you're last today. Go ahead.
Oh, good morning, all. I've just, in the last 6 months, the premises next door to me was completely demolished, and I've got cracks all through my plasterboard in my house and around my cornices. So I've had a surveyor and a assessor come out from the insurance agency, and I've knocked the claim back saying that there's already differential movement. So I was just wondering what avenue of inquiry.
Is this your insurer or the insurer for the neighbour?
My insurer.
Right. Well, I would be contacting so start with the council, so that would be Brimbank.
Yeah.
And what you want to do is find out the building surveyor who issued the demolition permit, and you need to see if there was a dilapidation survey required.
I'm aware, yeah. There wasn't one done.
And have you got some expert evidence that indicates that it was the demolition next door that caused your problem?
I've only had the assessor from my insurance company come out, but I'm 100% sure that it's happened because of it.
Well, I would go back to the assessor who says it's not, that it doesn't come from your property, but it's the adjoining property, and see if he or she will provide you an assessment that says it was as a result of the demolition work next door.
And with that, we'll leave you and your dog to try and advance that issue and take it forward. Gee, I've been enjoying having so many dogs on the program because of so many Zoom conversations, David.
Yeah, I've got 4 Zoom appointments this afternoon, so I'm busy. I'm getting sick of Zoom. You've got to pay attention on Zoom. That's
you really do. Yeah. Well, you've got to pay attention anyway. Have you got any dogs there at home, David?
No.
None.
We had 2 Maltese Shih Tzus, which were fantastic.
Bless you.
And but they both had long and fulfilling lives and are no longer with us anymore.
Buried somewhere under the apple tree. David, always good to chat. Are we getting you back into the studio next weekend?
Based on the announcements from Dan Andrews,
Yep.
I'm refusing to come back next week because it's Melbourne Cup, unless you're going to be there, Virginia, in which case I'd love to see you.
Well, I'll try and get the day
otherwise
off.
it's the week after.
But if they won't let me, will you come in?
Yeah, if they won't let you, I'll come in.
Yeah, okay, all right. Just be you and me. David Whiting, thank you so much. Our very generous Melbourne solicitor.